The room was quiet, but it was the kind of quiet that usually means something explosive is seconds away. Cameras were already rolling inside the committee chamber as Representative Jamie Raskin leaned forward, a stack of documents in front of him, and Attorney General Pam Bondi waited at the witness table. At first glance, it looked like another routine oversight hearing on Capitol Hill. But the question sitting in the center of the room was anything but routine, because this time the conversation wasn't about a minor policy dispute or a technical legal disagreement. It was about a single number that had suddenly turned Washington into a pressure cooker: $10 billion. That number came from a lawsuit tied to former President Donald Trump, who is seeking $10 billion from the federal government over the alleged release of confidential tax information. On its surface, the case is about privacy and whether the Internal Revenue Service failed to protect sensitive records. But inside the hearing room, Raskin was preparing to ask a question that made the situation far more complicated. Because if the President of the United States is suing the federal government for a sum that massive, and the officials who might ultimately negotiate or defend that claim operate inside the same executive branch structure, the constitutional implications become impossible to ignore. In other words, when billions of taxpayer dollars are on the table, who exactly is negotiating with whom? The hearing hadn't even fully heated up yet, but the tension was already building. Staffers along the walls exchanged quick glances while reporters adjusted their cameras, sensing that something bigger was about to unfold. Raskin spoke calmly at first, referencing the Domestic Emoluments Clause, a rarely discussed line in the Constitution that limits what a sitting president can receive from the federal government beyond their official salary. Most Americans never hear that clause mentioned outside a constitutional law class. But today it had suddenly become central to a live political confrontation playing out under the bright lights of a congressional hearing. Bondi listened closely, her expression steady. Anyone who has spent time in Washington knows that hearings often begin politely before shifting into something far sharper. For a moment, the exchange remained almost procedural. Raskin explained the legal background. Bondi responded cautiously, and the room stayed relatively calm. But underneath the surface, the real question was still hanging there, waiting to land. And when Raskin finally leaned forward again, the tone of the room changed instantly. He framed the situation in a way that forced everyone watching to think about the same uneasy scenario. If the president is suing the federal government for $10 billion, he said, and if the people responsible for negotiating or defending that claim ultimately answer within the executive branch itself, how does the Constitution expect that conflict to be resolved? The wording was careful, but the implication was unmistakable. The room suddenly felt smaller, the silence heavier. Bondi began her response by noting that she could not discuss active litigation, a standard position for any attorney dealing with a case still moving through federal courts. But the answer didn't quite address the deeper issue Raskin had raised. It was the first subtle moment where the conversation started to slide off balance, the question pointing in one direction, the answer drifting somewhere else. And in Washington hearings, those small misalignments are often the first sign that the real confrontation is about to begin. If moments like this matter to you, subscribe. Because this isn't where it ends. Because what started as a constitutional question about a lawsuit would quickly spiral into something much larger. Within minutes, the hearing would move beyond tax records and legal technicalities, touching on privacy violations, the handling of sensitive evidence, and the growing controversy surrounding the release of documents connected to the case of Jeffrey Epstein. The calm tone of the opening exchange would give way to interruptions, sharp procedural clashes, and a series of questions that neither side seemed eager to leave unanswered. And as the cameras kept rolling inside that hearing room, it became clear that this was not just another routine day on Capitol Hill. Something far more consequential was about to unfold. The quiet tension that filled the hearing room in the opening minutes did not fade. If anything, it thickened as the exchange between Representative Jamie Raskin and Attorney General Pam Bondi moved from abstract constitutional theory towards something far more immediate. The number that had been hanging over the conversation, $10 billion, was no longer just a headline circulating outside the chamber. It had now become the central point of the questioning, the axis around which the entire hearing seemed to turn. And everyone in the room understood that once a number that large enters a congressional conversation, it tends to pull in other issues, other controversies, and other unanswered questions. Raskin kept his tone measured, but his pacing slowed in a way that signaled he was about to unpack the issue more carefully. He acknowledged something that few people in Washington would dispute. If someone's private tax information is improperly released, that raises legitimate concerns about privacy and government accountability. Even critics of the lawsuit tied to former President Donald Trump have said that unauthorized disclosures of confidential records deserve scrutiny. But Raskin's focus was not just on the alleged leak itself. Instead, he pointed toward the unusual legal position that could emerge if the case ever moved towards settlement discussions. The lawsuit filed in federal court seeks $10 billion in damages from the Internal Revenue Service and the Treasury Department, alleging that government safeguards failed when confidential tax returns were disclosed to the media. The claim references the actions of a contractor who later faced criminal charges related to the disclosure of tax information. From a strictly legal standpoint, the courts will ultimately determine whether the government bears liability and what damages, if any, might be appropriate. But the scenario that concerned Raskin had less to do with the trial itself and more to do with what might happen if negotiations ever entered the picture. Because unlike most civil lawsuits involving private individuals, this dispute sits at the intersection of constitutional authority and executive power. The Department of Justice is responsible for defending the federal government in court. At the same time, the Department of Justice exists within the executive branch structure, and the president, by design, sits at the top of that structure. The question Raskin was raising, carefully but persistently, was whether that arrangement creates a complicated situation if the person seeking billions in damages is also the head of the branch responsible for defending the government's interests. Inside the chamber, several members of the committee shifted slightly in their seats. These kinds of questions are not unusual in congressional hearings, but they are rarely framed in such stark financial terms. $10 billion is not a typical damages request. To put the number in perspective, Raskin briefly noted that the figure approaches a significant portion of the annual operating budget of the Internal Revenue Service itself. In Washington, where budget debates often revolve around billions rather than millions, even seasoned lawmakers recognize when a number crosses into territory that demands closer attention. Bondi listened carefully as the argument unfolded. She had already indicated that she could not comment on active litigation, and that position remained consistent. Attorneys general, regardless of party affiliation, typically avoid discussing pending cases in detail during congressional hearings. It protects the integrity of the legal process and prevents statements from being interpreted as influencing the outcome of ongoing litigation. But Raskin appeared to anticipate that answer. His line of questioning was designed less to examine the specifics of the lawsuit and more to explore the constitutional framework surrounding it. He returned again to the Domestic Emoluments Clause, a section of the Constitution that rarely appears in modern political debate, but carries clear language about presidential compensation. The clause states that the president shall receive a fixed salary for the duration of the term and shall not receive any other payment from the federal government beyond that amount. Historically, the clause was intended to prevent financial influence from altering the independence of the presidency. The framers wanted to ensure that the president could not quietly receive additional benefits or payments that might compromise the integrity of the office. Raskin emphasized that point not as an accusation, but as a legal puzzle. If a lawsuit brought by a president against the federal government were to succeed, the courts would decide whether damages were appropriate. But the presence of executive branch lawyers, executive authority, and constitutional limitations all in the same scenario creates a situation that scholars might debate for years. The hearing was not meant to resolve that debate. Instead, it was meant to ask whether the Department of Justice had considered the implications. Bondi responded cautiously, reiterating that privacy violations deserve serious attention and that individuals whose confidential information is exposed may pursue legal remedies through the courts. She did not dispute that unauthorized disclosure of tax records can cause harm. But when Raskin returned to the constitutional question, asking again whether a settlement involving billions could raise concerns under the Emoluments Clause, the Attorney General held to the same line. She would not discuss the specifics of an active case. That exchange might have remained a narrow legal discussion if the hearing had stopped there, but it did not. Because as Raskin continued, he pivoted from the question of presidential compensation to a second controversy that had recently captured national attention: And in doing so, he introduced a topic that instantly shifted the emotional tone of the room. The conversation moved toward the release of documents connected to the investigation into Jeffrey Epstein, a case that has haunted American legal and political discourse for years. Epstein's crimes, and the network of individuals and institutions that surrounded him, have been the subject of countless investigations, lawsuits, and public debates. Survivors of Epstein's abuse have spent decades seeking answers about how the system allowed the crimes to continue for so long. For many of them, the eventual release of investigative materials was seen as a step toward transparency. But the release of those documents created a new controversy. According to attorneys representing several survivors, certain files made public by the Department of Justice contained personal information that should have been redacted. Redactions are a standard procedure in cases involving victims of sexual abuse. Names, addresses, and other identifying details are typically removed to protect privacy and prevent further harm. Yet some survivors claimed that their identities appeared in the released materials without proper protection. Raskin referenced reports that some victims' names appeared repeatedly across multiple documents. In at least one instance described by attorneys, a survivor's name reportedly appeared hundreds of times before corrections were made. Lawyers for the survivors argued that the exposure of that information caused renewed distress and potential safety concerns. Some individuals said they had received threatening messages after their identities became more widely known. The Attorney General acknowledged that the Department of Justice had taken steps to address the issue once it was identified. According to statements from the department, thousands of pages of documents were removed from public access while officials reviewed the redactions. The goal, Bondi explained, was to correct any mistakes and prevent further harm. In large document releases involving millions of pages, errors can sometimes occur despite review procedures. But the department insisted that it was working to fix the problem as quickly as possible. For Raskin, the controversy surrounding the redactions raised a broader question about priorities. If privacy violations can lead to massive legal claims, he suggested, how should the system evaluate the impact on individuals whose personal safety might be affected by the release of sensitive information? He did not accuse the Department of Justice of intentional wrongdoing. Instead, he framed the issue as a matter of consistency in how the government responds to different kinds of privacy concerns. The hearing room grew noticeably quieter as the discussion turned toward the experiences of the survivors. Attorneys representing several of them had argued publicly that the improper release of identifying information could re-traumatize individuals who had already endured years of legal battles. They pointed out that victims of sexual exploitation often spend decades attempting to regain control of their lives, and sudden exposure of their identities can disrupt that fragile recovery. Bondi expressed sympathy for the survivors and emphasized that protecting victims is a core responsibility of the justice system. She explained that the department's review process was ongoing, and that officials were working to ensure that any sensitive information was properly redacted before documents returned to public access. At the same time, she noted that the investigation itself had produced an enormous volume of materials, making the process of preparing files for release particularly complex. While the exchange remained civil, the tension that had begun with the constitutional discussion earlier in the hearing had not disappeared. Instead, it had shifted into a new dimension. The hearing was no longer focused solely on the question of a $10 billion lawsuit. It had expanded into a conversation about privacy, accountability, and how the justice system handles information connected to some of the most sensitive cases in modern American history. Observers in the room could sense that the hearing had entered a phase where multiple controversies were intersecting at once. On one side was the question of presidential lawsuits and constitutional limitations. On the other was the handling of documents tied to a criminal case that continues to generate intense public interest. Each issue carried its own legal complexities, and neither could be resolved through a single exchange in a congressional hearing. Yet the structure of the conversation made it clear that the two issues were not being discussed in isolation. Raskin's line of questioning suggested a broader theme: how institutions weigh privacy, power, and accountability when the stakes are unusually high. The comparison did not imply that the situations were identical. Rather, it highlighted how different kinds of legal claims can intersect within the same governmental framework. As the hearing continued, members of the committee prepared their own questions. Some appeared ready to focus on the legal technicalities of the lawsuit. Others seemed more interested in the procedures surrounding the release of the Epstein-related documents. The Attorney General remained composed, responding carefully while maintaining the limits she had already outlined regarding active litigation. What had begun as a quiet morning hearing on Capitol Hill had now evolved into something more layered and unpredictable. The central figures, Raskin and Bondi, remained at the center of the discussion, but the issues surrounding them continued to expand. Constitutional interpretation, civil liability, victim protection, and government transparency were all now part of the same unfolding narrative. And although no conclusions had been reached, the hearing had already accomplished something important. It had placed a set of complicated questions into the public arena, questions about how the law applies when political power, financial claims, and personal privacy collide in ways that the framers of the Constitution could scarcely have imagined. The answers, if they ever came, would not emerge quickly. But the conversation had clearly only just begun. As the hearing moved deeper into its second hour, the quiet procedural tone that had defined the early exchanges began to shift. The questions were no longer just about legal theory or the boundaries of constitutional clauses. They were becoming sharper, more pointed, and increasingly difficult to answer without touching on the political gravity surrounding the issues at hand. Representative Jamie Raskin leaned forward again, the same stack of documents still spread across the desk in front of him, and the tension that had been slowly building in the room seemed to tighten another notch. He returned briefly to the lawsuit involving former President Donald Trump, not to relitigate the case itself, but to highlight the broader question it had triggered. $10 billion is not merely a symbolic number in a courtroom argument. In Washington, that figure represents the scale of federal programs, national infrastructure plans, or entire agency budgets. When a lawsuit reaches that magnitude, the ripple effects extend far beyond the individuals directly involved. The question Raskin posed, carefully and without accusation, was whether the constitutional system is fully equipped to handle disputes that combine such enormous financial stakes with the unique structure of executive authority. He spoke slowly, almost as if inviting the room to consider a hypothetical scenario rather than a specific case. Imagine, he said, that the courts eventually determine that damages are warranted in a case involving the release of confidential tax records. Imagine that negotiations begin between the federal government and the plaintiff. And imagine that the plaintiff, in that situation, is also the person who sits at the top of the executive branch. The Constitution did not anticipate every modern legal complication, but it did attempt to create guardrails against conflicts of interest. The question, he suggested, is how those guardrails function when the lines between authority and liability begin to blur. Attorney General Pam Bondi responded with the same careful restraint she had maintained throughout the hearing. She reiterated that the Department of Justice takes privacy violations seriously and that individuals whose information is improperly disclosed have the right to pursue remedies through the courts. At the same time, she repeated that she could not comment on ongoing litigation. It was a legally sound answer, but it did not fully resolve the philosophical puzzle that had been placed on the table. And that puzzle seemed to linger in the air even as the conversation turned again toward the controversy surrounding documents connected to the case of Jeffrey Epstein. For years, Epstein's crimes and the network surrounding them have been the subject of intense scrutiny. Survivors have fought long legal battles seeking accountability and transparency. When documents from the investigation were finally released, many hoped that they might provide a clearer understanding of how such abuses were allowed to persist for so long. Yet the release of those files sparked another wave of controversy. Attorneys representing several survivors claim that some documents were published with insufficient redactions, exposing personal details that should have remained protected. Bondi acknowledged that the Department of Justice had removed thousands of pages for review after concerns were raised. According to the department, officials were working to correct any errors and ensure that identifying information was properly concealed before the files were returned to public access. The issue was not merely technical. Redaction errors in sensitive cases carry emotional and safety consequences for the people involved. Lawyers for several survivors argued that the exposure of their clients' names and personal information could reopen wounds that had taken years to heal. Some individuals reportedly feared that public attention could bring harassment or threats. Whether those fears would ultimately materialize remained uncertain, but the concern itself was enough to draw significant attention from lawmakers. Raskin acknowledged the complexity of the situation. Document releases tied to major criminal investigations often involve enormous volumes of material, sometimes millions of pages. Preparing those documents for public disclosure requires careful review, and mistakes can occur even in well-managed systems. But he asked a broader question about how institutions balance transparency with protection. When the government releases information in the name of accountability, how does it ensure that the process does not inadvertently cause further harm to the very people it intends to help? That question opened the door to a series of comparisons that quickly captured the attention of everyone in the room. On one side was the privacy claim connected to the $10 billion lawsuit involving tax records. On the other side were the privacy concerns raised by survivors whose personal information may have appeared in investigative documents. The two situations were not identical, and Raskin made that clear. Yet the contrast between them prompted an uncomfortable line of inquiry. How does the justice system weigh different kinds of privacy violations? Suppose, he suggested hypothetically, that a court were to recognize substantial damages for the release of confidential tax information. Would that precedent influence how courts evaluate claims brought by individuals whose identities were exposed in sensitive criminal files? And if not, why not? The point was not to equate the circumstances directly, but to highlight the broader legal principles that govern both situations. Bondi emphasized that each case must be evaluated on its own facts. The legal standards for damages vary depending on the nature of the disclosure, the harm suffered, and the specific laws involved. A tax record leak and a redaction failure in criminal investigative materials involve different legal frameworks. But even as she explained those distinctions, the underlying tension remained. The hearing had moved beyond a single lawsuit or document release. It had become a discussion about how institutions respond when privacy, power, and accountability collide. Observers in the chamber could sense that the conversation was approaching a more intense phase. Several members of the committee began flipping through their own notes, preparing follow-up questions. Some appeared ready to focus on the technical aspects of the document review process. Others seemed more interested in the constitutional questions raised earlier in the hearing. The Attorney General remained calm, answering each inquiry with the measured language of someone accustomed to navigating politically sensitive terrain. But the questions kept returning to the same central theme. How should the system respond when mistakes, or alleged mistakes, affect people at vastly different levels of power? If a private citizen's financial information is exposed improperly, the law provides mechanisms for compensation. If survivors of exploitation believe their identities were disclosed without adequate protection, the law also provides avenues for relief. Yet the scale and visibility of those cases can differ dramatically. One member of the committee asked whether the Department of Justice had considered additional safeguards before releasing large document collections in sensitive cases. Bondi replied that the department already employs multiple layers of review, including teams dedicated to identifying personal information that must be redacted. In complex investigations involving decades of records, however, the process can be extraordinarily demanding. The department's recent actions, removing files for further review and correcting redactions, were intended to address precisely those concerns. Still, the conversation did not fully settle the issue. The hearing was not a courtroom, and its purpose was not to determine liability. Instead, it functioned as a forum for examining the policies and procedures that guide federal institutions. Raskin returned to that theme once again, asking whether the department might consider additional oversight measures for future document releases tied to sensitive cases. The Attorney General acknowledged that the department constantly reviews its practices and that lessons learned from one case often inform procedures in the next. Transparency, she noted, is a core principle of the justice system. But transparency must be balanced with the obligation to protect victims and witnesses. Achieving that balance is rarely simple, especially when public interest in a case is intense. The discussion might have ended there, but another dimension of the controversy began to surface as reporters' questions from outside the hearing room echoed through the broader media coverage. Some observers had pointed out that various public figures appeared in the investigative documents connected to Epstein's network. Those references, however, did not automatically imply wrongdoing. Legal experts repeatedly emphasized that the presence of a name in an investigative record can reflect many things: contact information, witness statements, or routine background details, without establishing any criminal conduct. Raskin acknowledged that distinction directly. The purpose of releasing documents, he said, is to shed light on historical events, not to assign guilt by association. In fact, one of the challenges of large document disclosures is that fragments of information can be taken out of context. Names that appear in a file may generate headlines even when the underlying record provides no evidence of misconduct. The legal system relies on due process precisely to avoid drawing premature conclusions. That reminder brought the conversation back to the broader theme that had run through the hearing from the beginning: the importance of restraint when dealing with complex legal questions. Whether the topic was a constitutional clause, a massive civil lawsuit, or the handling of investigative documents, the underlying issues demanded careful analysis rather than quick judgments. And yet the tension inside the chamber had not dissipated. If anything, it had grown more pronounced as each topic connected to the next. A question about constitutional limits had led to a discussion about privacy rights. A discussion about privacy rights had opened a debate about transparency and victim protection, and beneath it all lingered the unresolved question that had started the entire exchange. If the federal government can be sued for billions over the release of confidential information, what standards should apply when other kinds of personal information are exposed through institutional mistakes? Should the law treat those situations differently, or do they reveal deeper gaps in the system's safeguards? These were not questions that could be answered in a single hearing, but they were precisely the kind of questions that congressional oversight is designed to surface. As the session continued, the room remained filled with that same uneasy awareness that something larger was unfolding. No one had accused anyone of wrongdoing. No legal conclusions had been drawn. But the questions themselves about power, privacy, and accountability had taken on a life of their own. In Washington, moments like this often mark the beginning of a longer conversation rather than the end of one. And as the hearing pressed forward, it became increasingly clear that the issues raised that morning would continue to ripple through courtrooms, policy debates, and public discussions long after the microphones in that chamber were turned off. When the hearing finally adjourned, the room did not erupt into applause or outrage. Instead, it emptied slowly, the way Washington rooms often do after something uncomfortable has been placed on the record but not fully resolved. Staffers gathered their binders, aides whispered into phones, and reporters rushed toward the hallway outside the chamber where cameras were already waiting. The exchange between Representative Jamie Raskin and Attorney General Pam Bondi had not produced a clear answer to the constitutional question raised earlier in the hearing. But it had done something else that hearings often do. It had shifted the conversation from quiet, legal filings into the public arena. Within minutes, short clips of the exchange began circulating across television broadcasts and online platforms. Cable news producers replayed the moment when Raskin leaned forward and asked how the Constitution is meant to function when a president sues the federal government for billions of dollars. The question was framed carefully during the hearing, but on television it carried a sharper edge. Legal analysts debated the meaning of the Domestic Emoluments Clause and whether it was ever intended to apply to modern lawsuits involving executive authority. Some commentators suggested that the clause raises legitimate constitutional puzzles. Others argued that courts, not congressional hearings, are the proper place for those puzzles to be resolved. The political reactions unfolded along familiar lines, but with subtle variations. Allies of former President Donald Trump emphasized that the lawsuit concerning leaked tax information centers on privacy rights and the responsibility of government agencies to protect confidential records. They argued that individuals whose information is improperly disclosed should have access to legal remedies, regardless of their political position. Critics, meanwhile, pointed to the scale of the claim, $10 billion, and questioned whether the situation could create complicated optics if executive branch officials are involved in defending the government's interests. Both sides insisted that the legal process should be allowed to proceed without political interference. Meanwhile, the second issue that emerged during the hearing, the handling of documents connected to the case of Jeffrey Epstein, generated its own wave of reactions. Advocates for survivors welcomed the Department of Justice's decision to remove and review thousands of pages of files after concerns about redactions surfaced. Several attorneys representing victims said the review process was an important step toward protecting individuals whose identities should never have appeared in public documents. At the same time, some legal observers noted that document releases tied to large investigations often involve enormous volumes of material, making the redaction process particularly complex. In the days that followed, major newspapers ran detailed analyses of the hearing. Some focused on the constitutional question raised by Raskin's line of inquiry. Others examined the administrative challenges faced by the Department of Justice when preparing sensitive documents for public release. Editorial boards avoided drawing definitive conclusions, but many pointed out that the hearing had revealed how multiple legal controversies can intersect in ways that the public rarely sees. A lawsuit about tax records, a debate about constitutional compensation limits, and a dispute over the protection of abuse survivors' identities had all appeared in the same conversation. Social media, as expected, reacted more quickly and less cautiously. Short clips from the hearing circulated widely, often stripped of the broader legal context that had shaped the discussion inside the chamber. Supporters of different political figures highlighted the moments that aligned with their own interpretations. Some viewers praised Raskin for pressing what they saw as an important constitutional question. Others defended Bondi's refusal to discuss ongoing litigation as a necessary safeguard for the legal process. In the fragmented world of online discourse, the same exchange could appear as either a moment of accountability or an example of partisan theater, depending on who was sharing the video. Inside Washington, the atmosphere around the hearing continued to evolve. Members of Congress from both parties offered cautious comments to reporters. Some said the hearing demonstrated why oversight hearings remain an essential part of the legislative branch's responsibilities. Others warned that constitutional questions should be addressed with care, particularly when they intersect with ongoing court cases. The Attorney General's office issued a brief statement reiterating that the Department of Justice takes privacy protection seriously and that the review of Epstein-related documents was ongoing. What changed most noticeably, however, was the tone surrounding the individuals involved. Before the hearing, the controversy had largely existed in legal filings and investigative reports. Afterward, the issues had been publicly aired in a high-profile congressional setting. That shift alone can alter the political atmosphere. For Bondi, the hearing meant that her handling of the document review process and her responses to constitutional questions were now part of a broader national conversation. For Raskin, it meant that the hypothetical question he posed about executive authority had become a topic of debate across legal circles and political commentary. None of that amounted to a legal judgment. Congressional hearings are not courts, and the exchange between the two officials did not determine whether any laws were violated or whether any claims would succeed in court. Instead, the hearing functioned as a stage where competing interpretations of legal responsibility could be presented to the public. In that sense, the outcome was not a verdict, but a set of questions placed into circulation. Those questions continued to ripple through policy discussions in the weeks after the hearing. Constitutional scholars revisited historical writings about the Emoluments Clause and debated whether its language could reasonably extend to modern civil lawsuits. Legal experts examined the procedures used by federal agencies to redact sensitive documents before release. Advocacy groups for survivors of exploitation renewed their calls for stricter safeguards when investigative materials are made public. Each conversation unfolded along its own track, yet all of them traced their origin back to the same moment inside the hearing room. Even among observers who rarely follow congressional oversight hearings, the exchange carried a certain symbolic weight. It illustrated how a single question, posed at the right moment in the right setting, can draw together multiple threads of legal and political debate. The question did not accuse anyone of wrongdoing. It did not claim to resolve the dispute, but it highlighted a tension that has existed in American governance for centuries. The challenge of maintaining clear boundaries between power, accountability, and personal interest. For some viewers, the most striking aspect of the hearing was not the sharpness of the questioning, but the absence of a definitive answer. Bondi's refusal to comment on ongoing litigation followed established legal practice. Yet the result was that the central question remained suspended in the air. What happens when constitutional language written in the 18th century meets the complex legal realities of the 21st? And who ultimately decides how that language applies? That unresolved tension lingered long after the cameras stopped recording. In legal circles, debates continued about whether courts might eventually confront similar questions in future cases. In political circles, commentators speculated about how such issues could shape future oversight hearings. But the hearing itself left the matter open, exactly where congressional oversight often leaves complicated legal debates. Because the hearing was never meant to deliver a final judgment, its purpose was to reveal the fault lines where law, politics, and public accountability intersect. And in that sense, it succeeded. It brought forward a set of questions that may take years to answer, if they are answered at all. In the end, the central issue remained exactly where it had been at the beginning. A question about how institutions respond when privacy, power, and public trust collide. No court ruling had been issued. No definitive conclusion had been drawn. But the conversation had made one thing clear. Sometimes the most powerful moment in a hearing is not the answer given, but the question that refuses to disappear. And that leaves one final question hanging in the space between law and public expectation. When something may not yet be ruled illegal, but still leaves people wondering about accountability and transparency, where does the responsibility truly begin? If questions like that matter to you, subscribe.